And of course, the man in the middle, Chief Justice John Roberts, somebody who we've talked about. He is, Terry, as you know, someone very opposed to the use of race in any policy. He, in fact, famously wrote in a dissent in 2016, the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race.
I could not believe how smart this guy was. You have to be at least that smart to write a book.
So with a private school, the challenge is going to be that it violates the Civil Rights Act. With a public school, the challenge is going to be that it violates the 14th Amendment. The challengers allege that the school unlawfully factored students' race into the admissions process, favoring Black, Hispanic, and Native American applicants, and even caused them harm by inviting them into classrooms for which they weren't prepared, which is true. The Thurnstroms, who used to write for The Atlantic, they documented very well the phenomenon of misalignment in which students are admitted to schools that they actually are not prepared for, and then they tend to flunk out of those schools at a higher rate. Now, the truth is that Supreme Court precedent here has been ridiculous because Supreme Court said that for some reason, diversity is in and of itself a public good. I'm not sure why. They never really explained why diversity is a public good. If they said that a wide range of human experiences is worthwhile to pursue in student body settings, that might be better. But when they say racial diversity itself is some sort of public good, there's no reason why that should be.
Okay, so when it comes to college admissions, affirmative action refers to policies where race and gender are considered in the application process. Now, they're not the only thing that colleges are looking at. They're still looking at your grades, your SAT scores, extracurricular activities, all that good stuff. But they also take into account your race and gender in an effort to help ensure that women and minorities are getting equal access to higher education. The idea was born out of the civil rights movement in the 1960s. Some see affirmative action as kind of like a counterbalance to legacy admission policies, which is when applicants get preferential treatment if someone in their family attended the school.
The Supreme Court has now said that it will decide whether to prohibit the use of race-conscious admissions in higher education. According to the Wall Street Journal, it's agreeing to consider challenges to policies at both Harvard and the University of North Carolina. The court, in a brief written order on Monday, said it would consider a pair of challenges by a group called Students for Fair Admissions. It's been led by the conservative legal activist Edward Blum. They sued both schools on the same date in 2014. The lawsuit against Harvard alleged that the school uses quota-like racial balancing tactics that artificially raise the standards of admission for Asian American applicants in violation of federal civil rights law. The challengers alleged Asians were admitted at a lower rate than whites, even though their overall academic scores were better. Harvard rejected the claims of discrimination, said it only considered race in a flexible way, as one factor among many in building diverse classes of students. Well, why is it even being considered as a factor at all?
It's an old and contentious issue now. Questions about the use of race in college admissions. They have been asked, answered, debated, discussed, argued over for decades, and now they're heading to the nation's highest court. This week, the Supreme Court justices announced they will take up a pair of cases to reconsider the legality of affirmative action under the Constitution and our civil rights laws, as they invoke some of the oldest and most elite schools, as well as state schools. A decision could be sweeping right across the higher education landscape, maybe into private hiring at companies and federal contracting, all kinds of other areas. So who brought these challenges and what's at stake?
Yeah, Terry, these are cases brought by a group of conservative students, mostly Asian Americans, who say they were discriminated against by Harvard University and the University of North Carolina in favor of Black and Hispanic students, essentially discriminated against on the basis of race. And they've been organized by a longtime opponent of affirmative action. His name is Edward Blum.
The Supreme Court, in the next term beginning in October, will hear challenges to the use of affirmative action. The case is seen as the most serious threat to affirmative action in decades because of the new 6-3 conservative majority on the court. The case claims that Harvard discriminates against Asian American students and that UNC discriminates against both white and Asian Americans because of affirmative action. I mean, first of all, when you see what the Supreme Court is about to discuss, we know that typically affirmative action has been upheld by a really thin margin. So what do you expect this time?
The opposite. It's been upheld by the thinnest of margins, one vote. And the last time it was upheld was before any of the three Trump appointees were on the court. The overwhelming likelihood, and I've got a lot of company here, unfortunately, is that, well, one will be held to a violation of Title VI of a federal law, and the UNC will be held a violation of the Constitution.
It may not fare very well, in part because while the Supreme Court has upheld race-conscious admissions, hasn't done so really enthusiastically, going all the way back to the Bakke case back in the 1970s. And one of the landmark reaffirmations of the constitutionality, the legality of affirmative action was the Grutter versus Bollinger case in 2003. Sandra Day O'Connor, the crucial vote there, saying, yes, affirmative action can move forward. But she said, I've got here, the court expects that 25 years from now, she wrote for the court in 2003, the use of racial preferences will no longer be necessary to further diversity in education. So Sandra Day O'Connor said, yeah, but let's put a time limit on this. While it hasn't been 25 years, it's close at this point. I wonder if the way the court has almost reluctantly upheld affirmative action will make it easier for those conservatives, those new conservatives in control of the court, to just steamroll it and outlaw it.
I mean, it is a pretty overt racism when students get in with 200 points less on the SATs than this Asian student over here, just because this Asian student happens to be Asian. This is what they used to do to Jews at colleges in the United States. Now they're doing it to Asians in the United States. It's absurd on its face. It is wild racism from the left. And yet the left continues to double down on this because obviously Asians are a supposed model minority according to the left, whereas black Americans are indubitably put upon. And therefore, black Americans only need a 1,300 or a 1,200 to get into Harvard, whereas Asians needed 19,000 to get on. They need to get a 19,000 on their SATs in order to get into Harvard. Under the Trump administration, the Justice Department actually supported that lawsuit. The Biden-era department abandoned that position and offered support for Harvard in a legal brief last month, urging the Supreme Court to turn away the challenge. The lawsuit against the University of North Carolina was similar to the Harvard allegations, though it added claims that the flagship public university in Chapel Hill violated the Constitution's guarantee of equal protection.
8 states have essentially banned affirmative action practices, and instead have what's known as race-blind admission policies. So, the New York Times looked at admissions data from public universities in a bunch of those states. In fact, Florida has actually done a pretty good job of keeping its enrollment of Black and Latino students at pace with the population, despite getting rid of affirmative action. Many opponents believe that affirmative action policies are themselves discriminatory and can actually create racial tension. They say that qualified candidates end up getting rejected from schools while less qualified minority applicants get accepted for the sake of diversity. They even have a term for this: reverse discrimination. And at elite schools, less qualified could be the difference between perfect SAT scores and getting one question wrong. And this discrimination is kind of what the Harvard lawsuit is all about. The plaintiffs are essentially claiming that Harvard is holding Asian Americans to a higher standard because they don't want too many getting in compared to other groups.